Hi, I'm Steven. In this video presentation, we will present our report on case between ASIC and Hellicar. We are from S1 Group 2. In February 2007, the Australian Securities and Investment Commissions, or known as ASIC, brought civil penalty proceedings in the Supreme Court of New South Wales against the respondents. They consist of 7 non-executive directors, a Secretary General, and 3 executive directors of James Hardie Industries Limited. For breaching Section 180, Paragraph 1 of the Corporation Act 2001, it was alleged that each of them had failed to exercise due care and diligence in relation to the release of information to the share market, and by doing so, breached their duties to the company. The proceeding arose out of the 2001 restructures of James Hardie Group of companies. 2 subsidiaries with significant asbestos-related liabilities were separated from the group, and the Medical Research and Compensation Foundation, known as MRCF, was established to fund compensation claims made against the separated companies by people injured by their asbestos products. On 15 February 2001, the board of James Hardie Industries Limited approved the separation proposal. The next day, James Hardie Industries Limited sent the ASX announcements outlining the proposal. The announcement contained misleading statements about the sufficiency of the fund available to the MRCF to meet present and future claims. The New South Wales Supreme Court held that 7 of the former non-executive directors breached the Act by approving an announcement to the ASX misleadingly, conveying that a trust created to fund asbestos-related disease claims will have sufficient funds to meet all present and future claims. It was later found that the foundation was underfunded by $1.5 billion. Mr. Saffron, as Company Secretary and General Counsel of JHIL, was also held to have breached the Act by failing to advise the board that the announcement was expressed in too emphatic terms, or that there were certain potential shortcomings with the economic advice and modeling received by the board from its advisor. At trial, ASIC tendered the minutes of the February board meeting, which recorded the tabling and approval of a draft ASX announcement. Those minutes had been adopted and signed as a correct record at the next board meeting in April 2001. 2 witnesses called by ASIC to give evidence about the board meeting were unable reliably to recall events. The respondents had claimed that the minutes recording tabling and approval of the draft announcement was false, and that the minutes were demonstrably wrong in other respects. Those of the respondents who have given evidence at the trial did not accept that they had approved a draft of ASX announcement. However, ASIC did not call Mr. David Robb, solicitor of James Hardie Industries Limited, who has supervised the preparation of the draft board minutes and had attended the February board meeting.
The trial judge of the trial found that the board had approved the draft announcement. As consequence, the 5 Australian directors and the 2 USA directors were found to have contravened and breached Section 180, Paragraph 1 of the Corporations Act in failing to exercise due care and diligence. Each of the directors was disqualified from being a director for 5 years, and each ordered to pay a pecuniary penalty of $30,000. Against this background, the directors appealed against the severity of the disqualification period as well as the pecuniary penalty. The 2 USA directors sought relief from liability under Section 1317 paragraph 2 and Section 1318 paragraph 1 of the Corporations Act, having regard to the fact that they participated in the directors' meeting by telephone and neither had read the ASIC announcement. Some of the directors appealed to the New South Wales Court of Appeal, submitting that the primary judge should not have held that the draft ASIC announcement, which ASIC alleged had been tabled and approved at the February board meeting, had in fact been tabled and or approved. The New South Wales Court of Appeal was satisfied that ASIC had not satisfied this burden of proof, given that the February board minutes, which recorded the resolution regarding the ASIC announcement, contained numbers of inaccuracies as to other matters which called into question their accuracy in general and specifically in respect of the ASIC announcement. And along with that, witnesses called by ASIC were unable to accurately recall events as to the tabling of the resolution. The Court of Appeal also held that ASIC owed a duty of fairness analogous to that owed by a Crown prosecutor, which it had breached by not calling James Hardy Industry Limited's lawyer, Mr. Robb, who had attended the meeting and prepared the board minutes. Failure to call Mr. Robb was held to diminish the cogency of ASIC's evidence in general. ASIC appealed to the High Court against the Court of Appeal decision. The New South Wales Court of Appeal held that Mr. Sheffron had acted in his capacity as an officer, either as a company secretary under Section 9, paragraph A of the Act, or as an individual who, at relevant times, participated in making decisions that affected the whole or a substantial part of the business of JHIL under Section 9, paragraph B, subparagraph I of the Act, and had breached his duties as an officer. Specifically, the Court of Appeal found that Mr. Sheffron had contravened Section 18, paragraph 1 by failing to give certain advice to the CEO and to the board, and by that failure did not exercise his powers and discharge his duties with the degree of care and diligence that a reasonable person would exercise in the same position. The Court of Appeal reviewed numbers of past cases with similar issues involving the severity of penalties and examined the circumstances of how the draft ASIC announcement was prepared and brought to the board's attention. Character references were provided and submissions made about the effect of the disqualification orders on directors. The Australian directors were successful in having their disqualification period reduced from 5 years to 2 years and 3 months, with one director having a slightly shorter disqualification reprieve. On the other hand, the Australian directors were ordered to pay a pecuniary penalty of $25,000 each, which was decreased from $30,000 before. The situation of the USA directors was more challenging for the court. The USA directors were in the unfortunate position of voting at the James Hardy directors meeting in favor of the release of the ASIC announcement, which seemingly was a consensus vote, without having a copy of the ASIC announcement or being able to see it. Both USA directors were participating by a telephone. The court dismissed the application for relief from liability and found that the USA directors failed to concern themselves with the terms of a critically important document, the ASIC announcement to be released. The court viewed this situation as paramount to the USA directors, abdicating their responsibility at the meeting in a situation where they could have asked for a copy of the ASIC announcement and abstained from voting on the resolution. That said, the disqualification orders preventing them from acting as directors were reduced to 1 year and 11 months. USA directors also received a lesser pecuniary penalty of $20,000 each, which was originally $30,000.
Let's now look at the High Court decisions. Against the decisions from New South Wales Court of Appeal, ASIC appealed by special leave to the High Court. Allowing ASIC's appeal, the High Court held the inaccuracies in the February board minutes did not counter their probative values as a contemporaneous and formally adopted record of what was done at the February meeting. Along with that, the court found that there was no basis for inferring that Mr. Robb may have given evidence favorably to the respondents. ASIC not calling him caused no unfairness. If it had, it would be wrong to respond by discounting the cogency of other evidences led to the trial. The question would be whether there had been a miscarriage of justice requiring a new trial. Therefore, ASIC's appeal was allowed and the matters remitted to the Court of Appeal for further consideration of remaining issues in the appeal to the court about claims to be excused from liability, penalty, and disqualification. Impacts on this case. A better interpretation of ASIC's duties has been provided by the decisions of High Court for this case, especially the duties in serving proceedings to the Corporation Act. On the other hand, the directors have also provided better definition concerning duties of non-executive directors, executive directors, and management board level. In addition, the definition of officer under Corporations Act 2001 has been clarified by these decisions. The lessons from this case are, it is clearly known the decisions for this case become a lesson to all public company directors, in which a public company director attending a directors meeting and a director is asked to vote on a matter on which he or she was not properly briefed, like the USA directors above, the director should have exercised one of these options. The first one is insist that he or she is fully briefed so that he or she can make a full informed decision as well as met the other criteria in the business judgment rule in the section 180 of the Corporations Act, or the other one, asking for an adjournment or delay of the meeting until the above applies or abstain from voting. A director's decision, as specifically stated by the supervising judges in the Court of Appeal, should be a reflection of consultation and consideration, and individual members of the board should note their own views and how to vote. In this case, a board meeting had been held where the two foreign directors participated by phone. In this event, they were incompetent to vote as they were lacking information. The other lessons arises from this incident. In case where one or more directors is participating by phone in a directors meeting, it is important that the rest participating directors who attend the person agree to perform the meeting in that manner. In other words, any change to the board composition activities, the requirement to reconfirm approval from directors for this protocol, regardless of what technology is utilized and how a directors meeting is held, each director participating must have full access to the document of matter discussed during the meetings. Therefore, each participating director must also be conscious of the contributions made by every single director without significant obstruction. So here we wind up our presentation. On behalf of our group members, Stephen, Cezin, Salman, and myself, Gerard Tuma, we thank you for everyone for paying your attention. Thank you.